the judgment. The Supreme Court held that Articles 352 to 360 in Part 18 of the Constitution relating to emergency provisions can be invoked only when there is an emergency, and the emergency is of nature described therein and not of any other kind. It was held that President's satisfaction has to be based on objective material. Therefore, the conditions for the issuance of proclamations are: first, the President should be satisfied either on the basis of a report from the Governor of the state or otherwise, first, and second, a situation has arisen in which the government of state cannot be carried on in accordance with the provisions of the Constitution. The proclamation under Article 356 Clause 1 is not immune from judicial review. Even though Article 74 Clause 2 bars judicial review of the advice given by the ministers concerned, it does not bar scrutiny of the material on the basis of which the advice is given. The power of dissolving the Legislative Assembly shall be exercised only after the proclamation is approved by both Houses of Parliament under Clause 3 of Article 356 and not before. Until such approval, the President can only suspend the Legislative Assembly. In case both the Houses of Parliament disapprove or do not approve the proclamation lapses. If the court strikes down the proclamation, it has the power to restore the dismissed government and revive the Legislative Assembly wherever it may have been dissolved or kept under suspension. With regard to the issue of federalism, the court held that the Constitution of India has created a federation but with a bias in favor of the centre. Within the sphere allotted to the states, they are supreme. The court held that secularism is one of the basic features of the Constitution. The proclamations in respect of Madhya Pradesh, Rajasthan and Himachal Pradesh are not unconstitutional. Impact. In one of the first instances of the impact of the case was seen in 1999. The central government headed by Sri A.B. Vajpayee had sacked the Bihar government headed by Srimati Rabri Devi on 12 February 1999, but the central government was forced to reinstate the Bihar government on 8 March 1999. In 2016, the Supreme Court, based on Bommai case, asked the centre to revoke the proclamation of President's rule in Uttarakhand and allowed Mr. Harish Rawat to assume the Chief Minister's office once again.